Well, welcome to the most recent event, our next event in a wonderful series of great conferences we've convened on looking at different aspects of technology policy and emerging issues that are coming up under the new Biden administration and also just in a very interesting time of technology law. My name is Christopher Yu. I am the director of the Center for Technology, Innovation, and Competition here at the University of Pennsylvania. And we are delighted to be hosting this wonderful event on the CASE Act, which is an important development in copyright law that we have established. We have invited and gathered a distinguished group of panelists to discuss. A couple of preliminaries. One is that this event will be recorded. So if anyone has a concern about that, please be aware of that. In addition, I'm just happy to tell, as I mentioned, this is part of a series of events. We did an event on March 23rd on the future of communications policy. We also have an event upcoming at 4:30 p.m. 5 p.m. on April 14th on the state of the nation, antitrust, privacy, and healthcare law policy in the Biden administration, which is also open to the public as part of this series of looking at new developments in the law. And we also are jointly sponsoring with the Penn Intellectual Property Group another event on April 12th at 5 to 6 p.m. Called Critical to the Future Experiences of a Moderna Senior Counsel Amidst the COVID Pandemic, featuring Khalil Mitchell, who is serving as a lawyer for Moderna at a time where that must be a fascinating job and a very interesting set of experiences that I'm sure you'll learn a lot and enjoy hearing from if you choose to join us, and we hope that you do. So without further ado, we're delighted to have you all here today. I'm going to hand it off to Nikki Barasa, one of our wonderful students who helped organize this event and I can tell you, is one of the people I enjoy having in class the most. So without further ado, Nikki.
Thank you, Professor Yu. Good afternoon, everyone, and thank you for joining us today as we explore recent and anticipated developments in copyright law. With yesterday's decision on Google v. Oracle, we certainly have a lot to talk about. My name is Nikki Barasa, and I'm a first-year JD MBA student here at Penn, and I'm a board member of the Penn Intellectual Property Group, or PIPG. PIPG is the student hub for those with interests in intellectual property here on campus. We organize events like this on current issues and provide professional development opportunities for students. This event is eligible for CLE credits, so you'll see two pop-up polls throughout this event that will go away after 20 seconds if you're not here for CLE credit. If you are, make sure you complete those. If you have questions throughout the course of this event, please enter them into the Q&A feature, and we encourage you to submit them throughout the discussion. Next, my colleague Manish Namireddy will introduce our speakers.
Thank you, Nikki, and thank you again, everyone, for joining us. My name is Manish Namireddy, and I'm a first-year student here at Penn, as well as a board member for PIPG. Today, we have the opportunity to hear from three panelists. The first panelist is Alex Moss. Ms. Moss serves as a staff attorney for EFF's intellectual property team, where she focuses on legal issues pertaining to innovation and creativity. Our second panelist is Abby Rives, who is IP counsel at Engine Advocacy, a nonprofit that bridges the gap between policymakers and startups across the country through research, policy analysis, and advocacy. Our final panelist is Professor Rebecca Tushnet. Professor Tushnet is the Frank Stanton Professor of the First Amendment at Harvard Law School, and her work focuses on copyright, trademark, and advertising law. Our moderator for this event is Professor Paul Wagner. Professor Wagner is the Michael A. Fritz Professor of Law here at Penn, and his research is focused on intellectual property law and policy with a particular interest in patent law. And with that, I'll turn it over to Professor Wagner to get our discussion started. Thank you.
Excellent. Thank you, Manish, and welcome to all of you who are coming. This is going to be a fantastic event. I'm looking forward to the next hour and a half or so where we can have a conversation about the CASE Act as well as copyright and what's going on in copyright these days. So the way I think this is going to go is I'm going to start here with maybe a little bit of an overview on the Case Act in particular, so that everybody, both attendees and otherwise, are sort of up to speed on that particular issue. And then I'll turn this over primarily to our panelists. As a reminder, if you are in the audience and want to ask a question, please do so in the Q&A at any time. I'll be continuing to monitor that, and I can incorporate those into the discussion as we go. And there'll be some ample time at the end where we'll do, we've set aside time to do specific Q&A aspects of the project. So without further ado, let me talk a little bit about the Case Act. So the Case Act was signed into law as part of this omnibus bill at the very end of 2020. And the CASE stands for Copyright Alternatives and Small Claims Enforcement Act of 2019. It was first introduced in 2019. The basic idea, if we want to think about it at sort of the highest level, is a version of a small claims court for copyright law. And it creates, in that sense, a new venue, primarily at this point an optional venue for copyright disputes that deals in particular, that has limited jurisdiction and limited amounts of damages that are at issue. The basic provisions of the Case Act are that it's going to create the Copyright Claims Board, otherwise known as the CCB, something I think those of us who teach and study in copyright law will be talking about for years to come. So this CCB is going to be populated by officers, which are effectively administrative law judges in the copyright claims area. The judges are specified in the Act, the officers are specified in the Act as having to have at least 2 of them with litigation experience in the copyright area, and 1 of them with alternative dispute resolution experience in the copyright area, all with substantial experience, by the way. And then the law actually specifically requires that they have represented both owners and users. So an intent, at least in the law, to try to get some balance in terms of the experience of the officers. There's also a number of copyright attorneys or CCB attorneys that are going to be hired, who are going to do things like screen the cases that come in for compliance and things like that. The Case Act promises a process that is optional. Although this optionality is via a 60-day opt-out system, whereby if you receive a notice of a claim against you and it's served on you, you have 60 days to choose whether to opt into the system or opt out of the system and potentially face other venues, particularly federal litigation, for dispute resolution. Damages wise, all damages are limited in the Copyright Claims Board to $15,000 per claim. Statutory damages are allowed in the way that they are typically done in copyright law, but the limitation is much lower. And so $30,000 is the maximum that can be in dispute in any particular case. So what's going to happen now is that in theory, the Copyright Claims Board could be up and running by the end of 2021. The law says as early as a year from the enactment, which would put it in December 27th, 2021. More likely, because of some aspects of the law that allow additional delays to happen if needed, more likely we're going to see this sometime in the middle of 2022. So we've got about a year and a half to try to figure out exactly how this is going to look. There has been a notice issued a couple weeks ago of inquiry concerning the regulations, because the Copyright Office is now directed to establish the detailed regulations that would specify exactly how these processes would run, exactly how the Copyright Claims Board is going to operate, things like service of process and stuff like that, all of which is yet to be determined. and that process is just getting started. So with that introduction, I thought maybe we'd start on the Case Act. We will get to other areas of copyright law that are going on right now, including we'll probably talk a little bit about Oracle versus Google. There's also the Digital Copyright Act proposals introduced by Senator Tillis. We have some trademark issues that are percolating out there that we'll probably talk about a little bit as well. But let's start with the Case Act. So what I'd like to do is maybe turn it over to each of the panelists and let them give their thoughts on the Case Act and their thoughts on what it suggests in terms of a future for copyright in the modern era. So why don't I start with Professor Tushnet?
Okay, so well, thank you for having me. So, I think there are a couple of things that are really noticeable. One is this sort of regulatory turn, so delegating more decision making to an administrative agency, which historically has not been what the Copyright Office has been, although there have been moves toward it slowly over the past few decades. And so we're seeing a real acceleration. So outside of music and outside of 1201, suddenly there's this very broad delegation on issues of infringement. Now, the immediate thing I think is there's a huge separation of powers problem. The Copyright Office is in the Library of Congress. There is no such thing as an Article I judge, except there is now. Frankly, when I talk to structural constitutional people about the Copyright Office, the usual reaction is like, no, that can't be a correct description of the rulemaking, because Congress can't make rules. But so I suspect that this will accelerate the prospect of a real challenge. And although I don't think it would be a good idea, I think the only constitutional idea that I've seen is to move the office to the Department of Commerce and make it an actual, administrative agency rather than a congressional agency. Which is, again, a contradiction in terms. So I think, one thing that will happen eventually is a real constitutional challenge. Related to that, I think there are important issues about the reviewability of these decisions, but I suspect the other panelists will take that up.
Okay, excellent. Yeah, so just following up a little bit on what Professor Tushnet was noting on the separation of powers issue, one of the interesting things about copyright law is that there is this, Copyright Office and a registrar of copyrights that sort of sounds like it's a administrative agency, but it's functionally located within the Library of Congress, which is in Article I, which is interesting, which is an interesting arrangement. Always has been a bit puzzling. So it's very unlike, say, the Trademark Office, which is an administrative agency under the Department of Commerce, or the Patent Office, which is also under the Department of Commerce. The Copyright Office is under the Library of Congress, under Congress, which is, of course, a interesting and might pose some particular challenges, as Professor Tushnet noted, in terms of the constitutionality, even beyond the copyright issues involved here. So, Abby, how about you? Why don't we hear a little bit about your perspective on the Case Act?
Yeah, just to reiterate, thanks to Professor Wagner, Manish, and Nikki for inviting Engine to participate in today's discussion and convening us on this interesting topic and the other copyright topics that are to come. I think from Engine's perspective, first of all, I agree with everything Professor Tushnet just said, and I think Alex can also speak to some of the other constitutional concerns around appealability and some of the due process aspects that give us concern that the Case Act will be subject to abuse. I think one of the things for some of the companies that Engine works with is some very small, some larger, like household names by now, like Patreon and Etsy, care a lot about their users being subject to abuse by potential copyright trolls or wrongfully found to infringe when in fact they're engaged in a fair use or a licensed use of copyrighted content. And with the absence of some of the traditional protections and safeguards that we're used to in court, there's a serious concern that users will be hauled before the Copyright Claims Board or not know to opt out, and so be subject to a default judgment before the Copyright Claims Board. And while, as Professor Wagner noted, the damages cap before the CCB is lower than what is available in federal court, it's still an awful lot of money for an awful lot of people in the country. $15,000 is a lot of money to me. $30,000 is an awful lot of money. And so when you think about the amount of money that people could be on the hook for, the fact that this could start scaring people away from being internet-enabled creators, being people who share and participate in vibrant internet communities on the various platforms that are out there and available, I think is a very serious concern for a lot of the companies that we work with.
Yeah, so it's a great point, and one that was often heard sort of in the run up to in the debate surrounding the enactment of the Case Act, is that this could potentially mean that more either small businesses or individuals could end up sort of being, for lack of a better term, sort of hauled into court, even though this isn't sort of a traditional court, for a copyright claim that otherwise might not go forward, I guess, is the theory. So you mentioned at one point that you were concerned that the optionality wasn't useful enough. Can you unpack that a little bit? What's the? I mean, it is as a formal matter, it is optional, right? If you get a notice saying you are, you've got a claim against you, at least we'll see what the regulations actually say, but at least the way that the law is written, it suggests that you're supposed to be told that you can just say, no, I don't want to engage, right?
Yeah. First, I did want to note in response to the start of your question, I think another concern around like what would the alternative be? Would you not be taken to court at all? I do think that, yes, maybe that's an option, but also when you go to court, the discovery available to you, the resources available in terms of people are expected to have counsel when they're in court. Counsel has a Westlaw subscription. They can develop the fair use defense, which is very fact-based and also dependent on the case law. And so there are ways in which we expect claims to unfold in court that the Case Act is set up kind of structurally to at least raise new barriers to advancing a case in that way. And then to your question about the optionality, I think kind of at the highest level for me, and as Professor Tushnet mentioned, and I think Alex can elaborate on with the constitutional flaws here, I feel like just as a baseline, we don't opt into constitutional protections in America. We are free to waive, like sign an arbitration agreement agreeing not to go to court. But this whole structure of Congress saying we're going to go ahead and decide to set up this optional space for adjudication of claims where money damages are on the table without some constitutional protections, and you can decide you don't want to go there, is kind of just the opposite of the way that I think about the constitutional protections working. And then practically speaking, I think that there's a serious concern that people who are going to be receiving these notices are not going to realize that they need to seek legal advice, aren't going to realize the implications of failing to opt out within that 60 days, might think that the Copyright Claims Board, a thing they've never heard of, is more like a Social Security scam that you get a phone call about. Children, elderly people will be receiving these notices, I think we expect. And so I think there's just a lot of ways in which, again, against a backdrop of a tribunal that feels a little unfair, the consequences of failing to opt out are significant, and it just feels like a lot of people are going to find themselves in that situation, unfortunately.
Okay, so Alex, let's go to you and hear some initial thoughts from you, and then we'll circle back to everybody on the panel to talk a little more about some of the things that we've explored. So go ahead, Alex.
Yeah, and thank you, Professor Tushnet and Abby, for a great lead-in on talking about the Case Act. And thank you everyone for coming and thinking about this. I think of the Case Act as like a bad solution to an earlier bad solution, with that earlier bad solution being the Digital Millennium Copyright Act. It was passed in 1998. in response, basically to deal with technology that probably most of you never dealt with. And by the time it got into law, the technology had already moved on. And so the complaint is, the theory behind the DMCA is that if a user put something that infringed up on a website or something that's sharing files, that the copyright owner could file a notice, get that taken down, and the user protective measures that the DMCA currently has is that a user can then respond with a counter notice and say, hey, that's fair use, or their complaint was bogus. And then in that case, the internet service provider has to put the material back up if the copyright owner doesn't file an action in district court. So this is a really big, the protection that Abby's thinking about is that if you're an ISP and you get a counter notice, that you may want to put it back up, but the fact that, and you're able to do that. And in fact, there's only about, I think a Stanford study came out to say that it's like less than 1% of DMCA notices actually end up producing counter notices. And the theory is that if the copyright owner still wants to go ahead with this and thinks there's a real case here, well, then it's time to go to a court. Now we've got a potential for taking down speech. There's a real dispute, and this is protected speech. We should have an Article 3 judge be supervising the proceedings. And this is really a way to get an end run around that. And instead of being guaranteed a sort of, as Abby said, there's a number of procedural protections that come into play pretty early in a case. And as a result, it's a lot of work for a copyright owner to bring a case. It's not easy, and it's not cheap. And as a result, frankly, at EFF, we see tons of demand letters to like small people who ran websites that are long defunct, radio hosts, professors, from copyright owners who really run kind of shakedown scams where they say, we've got a claim against you. Look how big statutory damages can be. Don't you want to pay us $1,500 and have us go away? And the thing is that with the Case Act, now for the first time, it may actually be efficient for those copyright owners to pursue those $1,500 claims and to pursue them before a really unfair tribunal. And right now, most of those claims don't get litigated because it's completely inefficient use of everybody's time. And so one of our biggest concerns is really, we've never seen this universe of low-level nuisance value claims be able to produce, court action. And so we're very concerned about the implications of that. And I think one thing about the Case Act that's interesting is I think to perhaps avoid a decision about whether a claim complies, they let the copyright board, copyright claims attorneys who get the claims, they have the ability to review them. And if they decide it complies, then they send out the notice with the opt-out. But that means there's not an opportunity to review that initial decision. And I think that one area where this will be very interesting to me is that the Case Act also allows defendants who think there might be might want a declaratory judgment of non-infringement to try to go to get one. And what that means, though, in this case is that you have an administrative attorney deciding whether there's a case or controversy, deciding whether there's declaratory judgment jurisdiction, which is very much the job of Article 3 courts. And I think that one perhaps unintended consequence, I think, of the opt-out too, is that once you've gotten an opt-out and if you've said no, I think it may be very hard then, if there is a declaratory judgment action in district court, I think it may be hard to say, there's no controversy here, there's no case. And so I think that there's many unintended consequences, but I think one that has been really not thought about is how this makes any sense for declaratory judgments.
Yeah, so all really good thoughts. Let me let me sort of throw out a couple of things that maybe the whole panel can talk about. So let's talk generally about this idea of having us, what is effectively a small claims court for copyright, right? I think Alex and Abby have articulated concerns that this is going to change sort of the equilibrium of enforcement in some way, right? That's going to mean that, as I think Alex suggested, because this could be, cheaper, more efficient model for enforcing copyrights, you may get more enforcement. Abby suggested that she was concerned that many of the companies they work with, their users would end up being sort of called into court when they might not otherwise, right? But what about, this idea generally that at this point, copyright infringement cases, because this is an exclusively federal jurisdiction, are incredibly expensive, incredibly complex. And so not only is it very intimidating to receive a complaint as a defendant, but as a creator, right? So let's say that you're not, a big movie producer or a motion picture studio or a TV company. Let's say you are, a small-time creator, either a, singer-songwriter or somebody who writes books or creates products on Etsy or something like that, that you want to enforce your copyrights on. Isn't it the case, and just sort of speaking abstractly, not getting too much at this point into the details of the system, wouldn't it be a good thing, though, potentially, to have a venue for determining these copyright disputes that is not quite so expensive, intimidating, and maybe not user-friendly as the Article 3 courts? So I'll throw that out to anyone on the panel who wants to talk about that.
I mean, I'm happy to do so. I think those are all completely valid concerns. And I mean, there are a couple of things going on that make this, at least I think, a worrisome solution for that. So first and foremost is the statutory damages. So, everything you say makes total sense. So why is there $30,000 in statutory damages, right? So if you look at small claims courts around the country, if we're actually comparing this to small claims court, that is literally an order of magnitude higher than the usual small claims claim. And, that's a problem. It's also, we haven't mentioned the fact that this, there has been, along with the statutory damages, this represents the first instance where you can actually get statutory damages, albeit lower ones than you could get in federal court, without a timely registration, which is, a fairly big deal in terms of the change in U.S. practice. So I do think, I think if this were an actual damages proceeding, or if the caps looked more like small claims caps, I think we'd have a lot less to worry about. But I want to talk a little bit about how that interacts with other parts of the law, right? So one thing that I think is distinctive about this process is the question of the reviewability of things, including conclusions of law, right? The reason there's an opt-out here, as there is not in, say, the Music Modernization Act rate court or the previous, rate courts even before the MMA, is Congress has provided that there's essentially no review. Like if there wasn't fraud, basically, and there was notice, and you like showed up and you made your arguments, unlike in a federal court proceeding where the court can usually review the ALJ's legal conclusions, or a magistrate judge's legal conclusions, or the Court of Appeals can review a district court's legal conclusions. They can't, right? That's it. They can disconfirm the award, but they're supposed to accept the factual and legal conclusions, absent some sort of core corruption of the process. That's a problem. And I think the possibility of an award sort of weighs into that. I would also just say, in terms of the constitutionality of the structure, I don't think we in IP have fully grasped how fundamentally the federal courts have been changed in ways that are going to have weird, somewhat random effects on intellectual property law. So a whole bunch of people have been hired for having a particular constitutional view, which for various reasons involves a greater deal of attention to presidential authority versus congressional authority than used to be the case. We have relied on copyright exceptionalism in the past. And frankly, just as patent exceptionalists found out that that was not going to work for them on the current Supreme Court, I think copyright people are going to find out. And I'm actually not, I don't think that's a good thing. Actually, I would prefer it would be different. But, descriptively, I think people may end up surprised by the extent to which larger changes in the conception of the role of courts versus the role of agencies versus the role of Congress are going to affect things like this. And then the last thing I want to say is, one consequence of having this be an opt-out system, right, is that Goliath is going to do just fine. When Goliath gets, the Case Act claim and says, well, you know what, if I ensure that you'll have to hire an attorney for this, this case will not go any further. You don't have a timely registration. So if I move this into federal court, you can get your licensing fee, you can't get attorney's fees. Goliath is going to do that. And so there will be a sort of adverse selection. And I think that's a problem, which could be fixed if we were willing to fix some of these other things. So, sorry for the rant.
Oh, no, fine. This is the discussion. Abby or Alex, who more thoughts on these?
My thought, I think in terms of the trend against exceptionalism, my first thought, frankly, is that if plaintiffs are finding it difficult to go to court, the problem is Iqbal and Twombly and the pleading standards, and that that I'm not sure that copyright plaintiffs are the most are the folks that are most troublingly impacted by that. So I think that's on the first. And also in terms of the fictional kind of the small creators and small artists who want to go use this proceeding. Before I became a lawyer, I actually worked with mostly like independent bands and musicians who liked the internet and thought it was a good thing. But the idea that more litigation by artists, that small creators should be engaging in more litigation instead of in other areas of law where we might be promoting settlement and efficient solutions and efficient breach. And so I think of that as it's important to be careful to think about the goal of copyright in terms of incentivizing creativity generally, and whether a increase in copyright litigation is the best way to do that is I think an open question.
Abby?
I don't think I have much to add, maybe just to reiterate some points I think Professor Tushnet first brought up, because I think especially for some of the companies that Engine works with that are platforms that are there and exist solely to serve a specific community of internet enabled creators like Etsy, like Patreon, like Reddit, like Discord, I think that for many of them and for their users, they would actually really like to see a fair proceeding, a fair place to bring claims when they do have somebody that really is infringing their copyright and taking their work. And as Professor Tushnet mentioned, I think we all expect the deeper pockets to opt out of the Case Act proceeding. And so those sorts of entities that can probably afford the $30,000 judgments are not going to be eager to go along with the Copyright Claims Board. And then just, I think this point about actual damages is a very, very important one, because I think were there a proceeding that was efficient and affordable and tethered to actual damages and harm that creators have suffered when there is an infringement, that would be much less subject to abuse and could really just be there as a place to hopefully efficiently and more affordably resolve actual claims of infringement without the risk of people who are engaging in fair use being threatened off of the platform for their creative works, for example.
Yeah. So one of the things that I found striking when you sort of look at the evolution of the Case Act itself from when it was initially introduced to what finally got in place is that there were a number of protections added that purport at least to try to address abuse of the process, right? There are abilities that the CCB can take to limit somebody from being able to file any more suits for another year or any more claims for another year. There are review steps by the staff attorneys that appear to be intended to weed out some potentially frivolous claims. I mean, one of the things that we have heard a lot about in the DMCA context is sort of the abuse of the DMCA notice and comment process. And it seems like, I mean, and I'll ask the panelists, do you think that you see any learning or any advances along that front in the Case Act in terms of having these mechanisms in there that seem, at least on their face, obviously the regulations will bear a lot on how these actually work. But do you think does that give you any comfort to see some of these quite specific targets against abuse of the process?
So let me say something positive and then something negative. So it is very clear that everyone is aware of the problem of notice, right? I think the office is going to do its absolute best, and hopefully it will be working with the best, behavioral evidence that we have. But I think the risks there just come from volume, right? Although I don't agree with it, I actually do understand the policy choice that is made, right? So it's as if we have decided, okay, we want actually to ticket everyone who goes over the speeding limit. Like, it is illegal, so we're going to ticket a whole lot more people by deploying automated means. And that is a choice you can make, definitely. So notice becomes a really big deal, and I think they're thinking very hard about that. I think the thing that will still be hard to handle is that these notices are going to go out to a completely new population, and that's where the trouble is going to come. There's no two ways about it. You can't get the benefit without getting the cost. There are clearly people in the audience who think that cost is fine, and I get that, right? That is a judgment call. But we shouldn't pretend that sending a whole bunch of notices to a new population that isn't used to receiving them isn't going to change the outcomes, and isn't going to change the understanding and the reaction of the population that receives them. And I think about like the people who represent small trademark owners on the trademark listserv that I belong to. Like, their clients get these fake notices all the time, and they just have to wade through them. That's actually an added cost. There is going to be definitely a new business model of sending infringement notices to small businesses, and they will just have to wade through that. And remember, you can now you don't actually have to go through the scrutiny of the system to get that. But the other thing I will say about the review process, so the notice stuff may well be helpful. We may be able to get notices that are pretty good for what they are. The screening part, no, the screening part is is it properly formatted, right? Do you claim to be the owner, right? And that's not the problem with a lot of these claims.
Yeah, so your view is the screening process, at least as articulated in the law right now, is really not sufficient to weed out sort of abusive notices.
Right.
Yeah. Alex, Abby?
One thing that to emphasize on the frivolous claims point, if you're in federal court, Rule 11 forces attorneys to engage in a reasonable investigation before they file, and to have an articulable ground for why they're bringing the case and why it's not frivolous. And there's nothing equivalent in the Case Act to that kind of protection. And I think there's really also not a provision for reviewing that decision to send the notice. And there, that's the way that the review structure is structured. There's really no opportunity to review. I mean, once in a district court, that could be a jurisdictional question that has to be considered, that the court has to consider, even if the defendant doesn't raise it. And now that's actually something that could never be considered, because once there's no reviewing for grounds that the claim shouldn't have produced a notice, shouldn't have been allowed to go forward. And once you're trying to challenge something afterwards, that initial question of jurisdiction is gone. So I am concerned about that being left to the agency, even with whatever protections have been added.
And unless I miss, so firms, including the Liebowitz firm, are hiring Case Act attorneys. So, and Richard Liebowitz is, still practicing law. So, make of that what you will for what the protections will be.
So, Abby, I'm curious, do you think that some of the companies that you guys work with will be able to or do sort of either outreach or support to their user community when it comes to sort of assisting them with Case Act notices that will in that way sort of improve the quality of the notice as well as their ability to respond without it being onerous?
I think that's a great question. And I also, to Professor Tushnet's point, I think it's apparent, or I see in the Federal Register notice that the Copyright Office put out that they are thinking about these things. And I think as the office thinking about what they can do to educate and make sure that the information is getting out there. And I think that's exceptionally important, especially given the statutory restrictions around other ways they might be able to tweak. This is one area where it seems like they're focused. And I definitely think, especially for some of the companies that we work with, this will be a very important part of the way they interact with their user base, whether that user be a creator or a more casual internet user. I think that said, for many of the companies that we work with, they're much, much smaller. They're not yet even close to being household names. And so the founder working with a small team just won't be in a position to even understand that him or herself. And so it'll be much more difficult to provide that advice to some. But I think as the platform gets larger, there will definitely, I think, be those sorts of efforts that we'll see get underway in the coming years. At least I hope.
Yeah. And Alex, what do you think? Do you think there's a role for EFF? I see that in the law itself, it specifically says that law students can represent people before the Case Act. Do you think law school clinics should and will get involved in sort of assisting with the process here? And do you think is that a useful thing, or is that from your perspective?
I think it'll be interesting to see. I think the fact that, this is an agency that is responsible for granting copyrights and increasingly, including in the Digital Copyright Act, may be given even more powers over enforcement. And so I think it's important I suppose I would have one concern of having, generations of lawyers trained on in a one-sided, framework. On the other hand, I think that there are a lot of opportunities for work in the administrative space, but also at sort of at a level of litigation for smaller companies and individuals. And I think so. I want to encourage students to who are listening to get involved and to look for opportunities in the copyright space, because I do think that there's just there's a lot of uncertainty, and so I think that is great. I am frankly a pretty big, I have a lot of respect for the federal judiciary. So it is hard for me to have equal confidence in an alternative.
Yeah. So let me sort of back up and ask this question. So what's the answer in the panelist view to, the question of from maybe a small creator, right? Saying, it's really hard to enforce my copyrights, whether I'm an individual singer-songwriter or a small-time artist, right? I mean, the Viacoms of the world are going to be fine, right? They don't need the Case Act, nor I think are they going to use it, right? I mean, that's not for them. The issue is more the small time creators, the people who are, essentially in the same position as many users of copyright, but are in fact creating their own copyrightable works. And the perspective of, it's really daunting to try to figure out how to prevent somebody from using your intellectual property without your consent or without payment or without at least acknowledgement. I mean, sometimes that may be all you want. What is it that we can and should do? I mean, Alex, you said earlier, oh, we should look at changing Iqbal and Twombly, but that's not going to do it, right? Like I agree that that's a barrier, right? But that's not going to do it, because we're talking about people who are nowhere even close to sort of that, federal pleading stage, where we need to figure out, or maybe we don't. I'm interested in your thoughts. How are we going to support, the small creators as well as the Viacoms of the world?
I mean, I think it's a really good question. What do small creators want, and how, if at all, does copyright serve them and make sure that they can get the support that they need? But sorry, is this yeah, but I'm going to pass it on as my mind for a moment.
All right.
So honestly, actually, I think there are versions of a small claims court that are a very good idea. But the compromises that were made to make this constitutional in the Copyright Office work against it, right? Like ensuring that Viacom is going to opt out. It's not going to use it on either side. Let me put on the table, why couldn't we have an Article 3 small claims court, right? You can write a statute that limits the jurisdiction of a particular federal court. It's actually, it's doable. You have to explain what you're doing about claim splitting and so on. But these are problems with existing answers. And we have bankruptcy judges, and yes, yes, you do have to be careful. On the other hand, like we already wrote, 40 pages of statute to do something, so it's not as if the statutory drafting got easier because we decided to stick it in the Copyright Office. And so, I would say, let's do some Article 3 small claims judges. Let's not have statutory damages, right? So the presumption should be you get a reasonable licensing fee, which can be established by any competent evidence. I think we would be much closer to a system that people could use, and you could use against Viacom, right? So Viacom could not actually get out a small claims court. And one thing that, a real small claims court does, it often does limit the amount of representation on either side, which does something to even the stakes.
Yeah.
That's a really good point. I just wanted to jump in about, I think that's a really good idea. But the point that you made, Professor Wagner, about the fact that artists often want attribution. And I think it's important to recognize that's our copyright law doesn't provide moral rights, doesn't provide a right to attribution. And I think also thinking of whether, legislatively, if we want to provide that, if we think that's important.
I mean, you could get attribution by a license, right? I mean, if you were able to effectively enforce your rights, you could get that, right?
But I don't know that you could force in the same way to have certainly in terms of negotiating the license, you could negotiate terms for the appearance of your name, but certainly you could be a musician who signed a contract and your record labels, has the rights and is putting things out there. So I could see, a right to attribution being useful in a, situation where we're thinking of creators and even those who might not actually still be the owners.
Yeah. Yeah. Abby, you were about to jump in, I think.
I just, I agree, especially with what Professor Tushnet said. I mean, I think there probably were opportunities along the way. I was working in patent litigation this time 2 years ago. So I wasn't around the table when the earliest conversations about a copyright claims court got started, but I think there were probably alternatives that could have been explored, but we're where we are now, and I think making improvements to the existing bill around actual damages, around access to counsel for accused infringers, making sure that the adjudicator decides fair use sua sponte, regardless of whether it's raised by the parties. And I am reminded specifically with Professor Tushnet's suggestion about my experience working with the alternative dispute mechanisms within the federal court system. I think it's a matter of federal rules of civil procedure, but if not, many courts' local rules require parties to at some point during the course of a federal litigation to go before a magistrate, to go before a mediator, and try to resolve the case outside of court. And if there were a way to provide those resources and funnel these small copyright claims disputes before those sorts of entities within the Article 3 system, I think that that's a very promising option.
Right. Although to be fair, lots of people have concerns about the arbitration system that are similar to the ones we hear related to this, right? Which is that it seems on its face to be cheaper, more efficient, more fair, but it tends to select out for to maybe systematically favor well-funded entities over small things. So for the last sort of topic on Case Act, and then we'll move on to some of our other things. How are you guys? We're a year, probably more than a year before we see this actually in action. What are the panelists going to do? What are you going to be focusing on? What are you most sort of concerned about? How are you going to try and engage in the process to make this as good as it can be? Or maybe you don't want to make it good at all and you're just going to fight it tooth and nail. Either one. Like what's the thinking over the next year to 18 months?
Well, I kind of assume we're all going to participate in various ways in the rulemaking. I think the concerns that we have can't actually be addressed by the Copyright Office other than in notice. And I think, as I said, I think they know very well that they have a very specific task and that there are existing tools for it. But in some ways, right, it's just a matter of wait and see.
We are at EFF, we are, as we don't have regulations yet, but we are at this point already trying to figure out ways that we might be able to challenge this constitutionally as early as we could. If folks know, it's not easy necessarily to show standing at this point, but we are investigating and hoping to come up with a way to challenge this early.
Abby, what about you guys?
I think we'll start by hopefully contributing perspectives that we hope can be useful to the Copyright Office as it implements the statute. And then I think we'll be following and watching as things get off the ground and seeing other ways that we could plug in to hopefully be useful to the companies that we work with.
Yeah. So let's move on to some other conversations surrounding sort of future of intellectual property in the modern era. I mean, I'd be remiss. I mean, we had a pretty important, actually, I'd be interested in your guys' perspective, copyright case come out from the Supreme Court yesterday, Oracle versus Google, which discussed whether or not Google's use of the Java API to construct the Android operating system was infringement under the copyright law. The majority didn't decline to decide whether or not there was copyrightability in the API. It assumed that there was, but did find that what Google did was fair use. There was a dissent by Justice Thomas, joined by Justice Alito, arguing that it was both an infringement of copyright and not fair use. Be interested in any perspectives that the panelists had on that opinion. Do you think it's an important case? You think it's a case we're going to be talking about for a while, or is it because they located the analysis and fair use, is it going to sort of just be another one of those difficult to discern fair use cases?
I mean, and I think for the importance, we consider it to be a very significant decision, in large part because of the claims that Oracle brought and just how pervasive that the implications of the copyrightability of APIs would be throughout the community of tech startups and software developers. And so in the sense of like that economic significance, I think it's a very, very big deal for us and the companies that we work with. On kind of going more to your question, I think we had argued in our briefs to the court as amici asking for a decision on the copyrightability of APIs, but I think the decision yesterday, which walked through the fair use analysis in the way that it did and looking at how API reimplementation works as a real core foundation of the reason why this specific instance was decided to be a fair use, hopefully will be useful to other folks who are using APIs in similar ways, not just to Google.
Yeah, so your view is that software developers who want to reuse APIs should take at least some comfort from the opinion, even though it didn't really, as you said, address the issue that many software developers want to address, which is copyrightability. It went on fair use. It nonetheless, you think, provides some comfort and guidance for their activities?
I hope that it will. And I also hope that we're not in a situation that those who can afford to make a fair use defense in court get to reimplement APIs and everybody else is out of luck, because of course that's a very expensive endeavor. So I'm hopeful.
Yeah, that latter is my concern about the opinion, because it is the case that, you know, Google won, but they won because they were Google, because they were able to litigate, right?
Yeah, that strikes me as a completely valid concern. But let me say, sort of on the other hand, right? So in your future software case, you will still have to show, suppose they decided that APIs were not copyrightable, right? In your future software case, you would still have to show, like, well, you know, to someone who almost certainly does not know what an API is, right? And could not identify an API if it were slapping them in the face, is what you have an API, right? So Oracle, of course, invents a whole bunch of terms, declaring code and implementing code are actually a new thing from this case, right? They used to be called declarations.
Right.
So I will say, you know, abstraction, filtration, comparison, right? Substantial similarity. Those things actually ended up requiring experts too. That is not to say that I don't share this concern, but it is possible that we are exaggerating the ease of a no substantial similarity, no protectability finding. And it also matters, I think, very much that the court held that fair use is a mixed question of law and fact, leaning toward the law side, right?
Yeah, that I think that is an important holding.
Yeah, so that's gonna, you're still gonna have to do summary judgment in many cases, but summary judgment is gonna be appropriate in many cases. So the current practice won't change very much, I think. And the practices of courts of appeals reviewing won't change very much.
Right. Yeah. Alex?
I think both of those points, I think, are interesting to think about how that might affect actually the Case Act, because the opinion does really emphasize the historical right to a jury trial, both on infringement and then specifically on fair use. And as Professor Tushnet said, it describes the ultimate question of fair use, this thing that could lean towards being legal, which gives me some optimism about it. You know, district courts being more willing to dismiss cases on the pleadings in fair use. And my hope is that at least perhaps this will be, there may not be many cases that are this close, but I think there is a lot of language that, you know, defendants will be able to use and say just like this. And so I think that the way it was written out, at least for some cases that are really close, it might be helpful.
Yeah, good. Any further thoughts on Oracle versus Google?
So I gotta mention that this hilarious judicial practice that Breyer engages in. So in copyright case after copyright case, right, the court will say, like, the question is whether this work was infringed, and then reproduce the whole damn thing, right? And I just love that. My favorite is the entire text of Action Comics #1 is including the images, like the entire reproduction of Action Comics #1 is appended to the termination of transfer decision about Action Comics #1. All right, and so there it is, completely public. And lots of fair use cases do this, and Breyer here does it to like some completely inoffensive, unrelated short story. He just plunks it in there twice in 2 languages, and I just love this judicial practice because it's such a good demonstration of everyone thinks their own stuff is fair, right?
Yes.
And I actually agree with that, but one would not. It would not be completely unwarranted to say, hey, wait a second.
Yeah, that is, I had never really thought about that quite that way, but it is true. They do that all the time in these copyright cases, is reproduce large swaths of copyright.
Right, in Warhol, right? Like just all the time.
Yeah. So let's talk a little more broadly about sort of future reform, changing efforts in over the next few years. So Tom Tillis, Senator from North Carolina, has introduced a sort of discussion draft, what he calls a Digital Copyright Act. He actually introduced it just a couple days before the Case Act actually got enacted. So part of it includes some aspects of the Case Act. This has a number of, I think, what would be pretty substantial proposed changes, including moving the Copyright Office into the Commerce Department, which is something that Professor Tushnet noted earlier. Some efforts to reform the notice and takedown system, including some work on 512F issues, which are the misrepresentation aspects of notice and takedown. So maybe I'll throw it to the panel and let you guys talk about it. I'm sure you're familiar with the Digital Copyright Act proposal. What do you think? Is this a good thing, bad thing? Do you see other proposals on the horizon that are also likely to get some traction? Is this likely to get any traction? What are the thoughts?
Look, I can't make political predictions. I will say that the general approach of this bill, as far as I can tell, is content ID is so bad that everyone on the internet should be forced to use it, right? So, right, because the claim justifying this bill is that Facebook and Google aren't paying us enough money. So they, of course, have very robust automated screening systems that go way beyond notice and takedown. So the bill proposes, well, everybody should have to do what Facebook and Google do, which is, it's just, I would call it the, Facebook and Google Monopoly Preservation Act, if I could.
Not a fan.
Not a fan.
Yeah. Alex, Abby?
I think Professor Tushnet's right that one of the most sweeping changes is it's like filters, and it's more of these automated filters that have never worked. Study after study, they don't work. Hollywood's complaining they don't work well enough, and so they're going to make everybody use them. And they also are some of the most troubling provisions are for cutting off repeat infringers. Right now, the DMCA says to internet service providers that they just have to develop a reasonable repeat infringer policy. And I think one of the things the DCA would do is say, actually, the Copyright Office is going to write that policy, and that's going to be how people's internet service is terminated. And so that's the thing we're watching and really concerned about.
Yeah,
I agree with those points. Definitely the problems of filters, but also the costs associated with implementing them, and then the liability or the legal costs associated with operating a company when the filter fails, which it inevitably will. And when you think about how pervasive content is and how big the internet is and how many people there are out there with a blog that has a comment section or a small platform that's just getting started and trying to get a foothold in the market with just its first few users, putting those sort of costs and risks on smaller companies is going to be something that some folks won't be able to afford, so they won't even enter the market. Some things that some investors aren't willing to invest in, and so we'll see a shift in investment away from some of the internet startups that we work with. And I think exactly what Professor Tushnet noted, we're in a reality where Facebook, YouTube, these big platforms already have very, very sophisticated technology, so would probably be compliant with the law on day one. And so it's really the smaller guys who experience very, very little, if any, infringement, who would have to fundamentally change their business model and might not be able to afford to.
Right. Why do you think Mark Zuckerberg wants Section 230 changed? Right. It's not. It's not out of the goodness of his heart. It's because he's already hired 100,000 content moderators. And actually, I do think it's worth emphasizing, for people who aren't embedded in this debate, right? The internet is not YouTube. It's not even Google. So one of the things that I find really useful is to talk about just like takedown statistics, right? So Google gets a ton of notices, it's true, and there are issues with those notices, we can talk about them, but let's assume that all those notices are right. If you compare some other very large websites, Wikipedia does not get anything like the pound for pound volume of notices because Wikipedia's content is very different. If you made it filter, right, Wikipedia would go down despite the fact that there's not an infringement problem on Wikipedia. It's not that, something, infringements occasionally pop up, but the percentage of valid claims as well as the absolute number of total claims is much smaller. And that's true, for websites like the one that I work with, the Archive of Our Own. We have 6 million pieces of content and basically under one valid infringement claim per year, right? And so the disproportionality of imposing on everyone a solution that is offered as if like every site were packed full of infringement, I think is a real problem.
Yeah. So are there other reform efforts in copyright on the horizon that you guys have seen or that you're hearing about, that you're interested in or excited about, that you think would be steps forward?
This is an answer, I guess, to the first part of your question, not the second half. We're, of course, watching as the European Union member states are, in some cases, I think, struggling to implement Article 17 of the Copyright Directive. And so I think a lot of the issues that are in my daily conversation and are in conversations here in the United States with policymakers in these areas, I think some are already being informed by watching the European experience, and others will soon have to be informed by what happens in Europe, because I think they're going to experience some of the practical problems with over-reliance on filters, for example, before we do, and companies that are operating on both sides of the ocean will begin implementing some of the measures that may be vary across different member states. So there's going to be, I think, some confusion there, but also opportunities for us as a country to learn.
Mm-hmm. Yeah, interesting. No other good reform issues coming up. So there's another reform, trademark related. The Shop Safe Act has recently been suggested. I don't know if it's actually, I guess it was introduced in the House. So this appears to be essentially filters for trademark, right? Some sort of system whereby the eBays and the Amazons of the world are going to, and others, I assume, are going to have to police counterfeit goods much more stringently than currently. Thoughts on this from the panelists?
So I guess, again, this is actually, I think, a very stark policy question, and there are worlds in which we answer this differently. But I will note that the Case Act is based in part on a paper that argues that China has this system for verifying that you are who you say you are and that you are operating where you say you are. And because it's a totalitarian state, they can do that. Now, of course, they actually don't, right? Which is why part of why there's a big infringement problem. But in theory, the law in China requires you to be sort of knowable as a seller. And that's the basic idea. And so the Shop Safe Act, right? We could have essentially a national ID system for sellers, right? You'd have to identify who you were. If the platform couldn't, get its hands on you, then the platform is itself liable for your conduct. And I think the Shop Safe Act is probably a bad idea, but the basic problem is a real one, and we really need to start thinking about it. I think in tort cases are starting to deal with this, and it's not really counterfeits. Like counterfeit is not where the big harms are coming from, but things like product liability, right? So there's like if a product is being sold, from China, who is responsible for that? I do think we need to sit down and have a conversation about that. I don't think focusing on counterfeiting is a particularly good idea, because it's not where it's not why we ought to care, basically.
Yeah. Other panelists?
I agree with that perspective, and I think when I think about what the Shop Safe is endeavoring to accomplish, I think about like buying an exploding battery online, and somebody, as Professor Tushnet mentioned, like you suffer a personal injury. And what is the solution to that problem? And I think that warrants a discussion. And I just hope that the small e-commerce platforms that want to get up and running aren't collateral damage in a conversation around what to do about an unrelated problem. And on the front of identification, verification, of sellers, I think it's just like really important to think carefully about what the whole universe of that would look like. And one example that is brought to my attention on occasion is when you think about small sellers who are using a platform like Etsy or any other e-commerce platform to sell things that they make in their own home. And for example, if you're making work that is supportive of LGBTQ communities, but you live in a region of the country where your neighbors might not agree with that perspective, the sense of your own personal safety might drive you away from making the work that you want to be making and engaging in the commerce that you want to be engaging in. And that doesn't advance the goal of making sure that people aren't buying harmful products. It really just allows the fact that you might have to basically dox yourself to keep you out of participating in this part of the market, which I think would be a very unfortunate outcome.
Yeah. Other thoughts? So we do have a number of questions, some of which we have already talked about, but let me go through and ask you guys to answer a few of the questions from the audience, since we're down to about 15 minutes left. So we have one here that says, do you foresee that parties may license or to a license or other arrangements might stipulate there would be dispute resolution at the CCB as opposed to other tribunals? Do you think this will become a tribunal that will be attractive or useful for parties who want to use it, maybe as an alternative dispute venue?
That's a super interesting question. The only analogy I can think of is parties agreeing to have disputes resolved by the NAD, the National Advertising Division of the Better Business Bureau. And there's one case of which I'm aware where a court actually orders them if subsequent disputes arise, to go to the NAD, and then courts vary in how much they're willing to defer to the NAD. I find it hard to imagine a scenario where that makes a ton of sense, but maybe. So maybe if you have this ongoing licensing dispute, maybe you could say, well, we'll settle it with the copyright judges, but I honestly don't I don't see a standard case for it, I guess I'd say.
Yeah. Other thoughts on that topic? I mean, it is an interesting question about whether it becomes a venue that is regarded as authoritative and attractive, right? I mean, that would be the question, and I think we won't know that probably for several years after it gets running. Another question, the Case Act includes more protections against abuse than actually exist in federal court. For example, you can get banned from using the tribunal, you can get limited, etc. None of these are typical of federal court, and Rule 11 is not often used. Isn't that an example of at least an effort to try to avoid the abuse that some of the panelists have noted could emerge?
So I guess I don't get this as a response. What makes you think they'll be used any more often in the Case Act? Right. So at most there's a big question mark, but you can actually get banned from filing in federal court. Like, it's hard, but it can be done. And as I said, Richard Liebowitz, by the way, is only now possibly, right, and he's working on getting himself banned in various ways, but it has taken a couple thousand lawsuits. So
yeah, Rebecca, we had another question to explain the Richard Liebowitz reference.
So Richard Liebowitz is a guy with the noble goal of helping photographers, who has gone about it in a pretty destructive way. I frankly think that people who like fair use are much better off because Richard Liebowitz has filed all these cases, but people who like expansive rights for photographers are much worse off because he's filed so many photographer cases, because he's done it badly in various ways and compounded some of his strategic and tactical errors by lying to courts, including about the death of his grandmother, not coming to settlement conferences. Don't do that to a federal judge. Like, if there's one thing they don't like, it's misbehavior targeted at them. So as a result, Richard Liebowitz has generated a noticeable percentage, a plurality of the fair use cases in the last year, which is actually an impressive feat for an individual. And he has indicated every intention of ramping up this business model of suing lots and lots of people for photograph infringement. And look, I am not in any way saying that federal court can't be abusive. What I think is the important thing is, if the model of the Case Act is to have 10,000 more claims a year, then we're going to have 10,000. We're going to have a new population, and that new population may not be the old population. That's a pretty standard result.
And one other point on that one thing that we get in the courts that we won't get in the administrative agency is the presumption of public access to what happens in the proceeding. And Richard Liebowitz has done so many cases. There's an amazing record to see that the public can see. And the truth is that whatever misconduct occurs, I don't think we have any notion that the public will have the same sort of sunshine into it.
Good. All right, let me see. We have a question here, can probably be quickly answered. What is copyright exceptionalism?
The idea that copyright is special, so that structures or rules that wouldn't be accepted in other areas of the law would count in copyright. So so if you can compare like the special structure of patent judges and the PTAB, recently the Supreme Court in Arthrex said no, regular administrative law actually applies, right? And that kind of intellectual property is different reasoning that in the past has actually been persuasive in many cases, I think.
Yeah. So another question we have is for anyone on the panel that was specifically directed to Alex. So is it a useful thing with the CCB that once the CCB is up and running, an individual or small business that gets a demand letter can go to the CCB and get that resolved, get a declaration in a way that is significantly less onerous and expensive than might be the case in federal law? Is that something that you think is a useful aspect of CCB or not?
Frankly, I think it may be useful for challenging the Case Act, but it certainly could be something that is helpful. I think the concern, though, is that a defendant who wants to get a declaratory judgment is going to, or whether they're going to have to hire a lawyer either way. And if they hire a lawyer and go to federal court, they also produce benefits for the world, and that's why there is a interest in the public of encouraging defensive litigation. And if the other side's case was so bad, they might be able to win fees. So for a defendant to go to claims court where there's still a potential of up to $15,000 at issue, it is hard for me to see a world where a defendant who's willing to fight and to litigate is going to prefer the Copyright Office administrative agency to a federal district court. And I also think that has, I'm not sure the drafters put a lot of thought into that, because I'm very curious. The decision about whether a claim has been made is, I think, supposed to be a fairly ministerial one, but it's not clear how the decision about whether there's a case or controversy, it's not clear to me how that's going to get translated to the administration. So
Right.
It frankly looks to me like they're not expecting that to be the major use case. And I think there are good reasons not to expect that. But nevertheless, I think it's really interesting. And I think if it exists, it might, for example, allow defendants who would want to bring a declaratory judgment action, but wouldn't have a case in controversy. I wonder if they could use it, get the notice out, and then when the person opts out, say, oh, there's a case in controversy, and we couldn't litigate it there. So I think there's a lot that's interesting about that.
Yeah, that is an interesting interaction, right? The interaction between the notice, the opt out of the notice, and whether that generates a case or controversy under Article 3. Anyone else want to weigh in on that? So we have another question here that let's answer about fairness and expertise. So one view of a more fair tribunal for resolving these sorts of claims is that by its terms, the law will require the CCB to have subject matter expertise in copyright. Do you think that's a step forward, right? Because right now, when we're talking about federal courts, by and large, they are not experts in copyright law, certainly not experts in technology. And here, you've got at least the practice or the promise of a board that's going to be experienced at the beginning, and then by virtue of doing this all day, every day, they're going to build up a significant amount of expertise in these proceedings. Is that what do you think about that? Is that make this more likely to be a fair and useful tribunal than would otherwise be the case?
So let me say a couple things about that. First, just to, there's a very large question and about specialist courts, right? So there's a robust discussion in the literature. Are specialist courts a good idea or a bad idea? And we can't even begin to scratch the surface of that. Mostly the U.S. has said no. It is the big risk is capture and then sort of becoming inured to. So here's a comparison: landlord-tenant court, right? A very specialist court, because of case selection. It is a rubber stamp for creating evictions. And again, maybe that's the way we want the world to work. But I guess I don't think without a lot of more information, you can actually say very much. The thing that worries me, maybe not the other panelists, but historically, fair use in particular has actually relied on levels of appellate review. So, if you look, a lot of our big important cases are reversals, on both sides, to be super clear, right? Harper and Rowe, is a plaintiff win that reverses. Warhol is a defendant win, well, you get my point. A bunch of people end up with different results when they go all the way through. We have thought that that's important for the development, particularly of fair use law, but also for things like, what constitutes infringement. And so abandoning that process of development has significant costs that concern me.
Yeah.
One other thing that when I think about the idea of the CCB in particular, is there types of questions that judges in the federal court system routinely decide in every case, regardless of what the subject matter is, when we're looking at damages, when we're looking around questions of discovery, admissibility of evidence. And those are some of the areas where I think the problems of the Case Act really might come to fruition. And so having a judge who's thought about damages, not just in the context of copyright claims when statutory damages are available, but really thinking about and listening to experts around measuring harm in the legal system. I think there's a missed opportunity to have folks who have expertise in thinking about those sorts of questions.
Mm-hmm.
I agree. I would also add, I wouldn't sell district court judges short. I think Judge Alsop in the first Oracle decision, learned Java, learned the code, understood it that well, spent that much time with it, lived with it. And I can guarantee you that the appeal court did not spend that much time, and that nobody learned programming. And so I think there, especially in California and in New York, I think you actually have district court judges who have a ton of copyright experience. And so for a lot of, in the Northern District, we have a lot who were copyright litigators. So I think that's, I would also not assume that the experience is going to be greater at the agency.
Yeah. So we have a question. We're running short of time, but let's try and get a couple more done. Are our panelists paying attention to the DMCA 1201 hearings that are coming up in the next few weeks? And if so, what are your thoughts?
So the organization I volunteer with is participating in those actually earlier today. So definitely paying attention. Hopefully the Copyright Office has responded to problems with previous rounds in ways that I think are, certainly extremely good faith. Limited helpfulness, but it does mean that existing exemptions have a much easier path to renewal. And then the question is, every time things change, right, which of course with technology, they're changing all the time, there are, then you have to go back and tweak the exemptions. But yeah, I think people are paying attention.
Yeah. Let's see. One last one for tonight. What do you view as the role of the volunteer lawyers for the arts and other organizations like that in the debate over the implementation of the Case Act? What can people do if they want to get more involved, whether they're a volunteer attorney, whether they're a law student? What would you suggest?
Certainly the request for comment period is just beginning, I think, and so I think I would certainly really strongly encourage anyone who is interested, as any perspective on this, please submit comments. And if I do a lot of patent law, and you'll see in the patent space, you have a lot of people who just have their own experiences that they want to share, and I just would encourage everyone who cares to say something.
Yeah, I agree. I also think that the Copyright Office has always expressed openness and willingness to hear from various stakeholders. And so I think I think the comment period actually closes in 20 days. So if you can't get your comments in the next 20 days, I think that there will still be opportunities to participate and provide input. And I even suspect that the Copyright Office employees themselves would welcome the opportunity to hear like very concrete experiences and stories that can help inform their work.
Good. All right. So we have reached the end of our time tonight. And I want to thank our panelists, offer you an opportunity if you have any final thoughts to throw out there before we leave, to do so now. And if not, thank you for coming, and thank all of our participants. And thank you for what it was a really interesting and enlightening discussion. All right. If not, thank you very much. Take care. Everybody have a good evening, and we are done with this event. Thanks, everybody.